Thank you, Judge Pragerson, and may it please the Court. My name is Gregory Garr, and I'm appearing here today on behalf of the United States. Your Honors, the nation's top officials, whose job it is to assess and protect foreign intelligence, have determined that litigating this action could result in exceptionally grave harm to the national security of the United States. They've reached that judgment because litigating this action would require the adjudication of three central facts, each of which directly implicates state secrets. First, whether or to what extent any secret intelligence gathering relationship exists between AT&T and the government. Second, whether or to what extent any alleged surveillance activities have taken place. And third, whether or to what extent any particular communications have been intercepted. As the Director of National Intelligence and the Director of the National Security Agency have explained in the public and non-public declarations filed with this Court, litigating those central facts could compromise the sources, methods, and operational details of our intelligence gathering capabilities, and equally important, could disclose potential gaps in those capabilities.
The state secret doctrine is a common law doctrine, isn't it?
Your Honor, this Court described it as a common law doctrine in the CASA decision. In our view, it also has constitutional underpinnings. We think that's supported by the Supreme Court's decision in United States versus Nixon. It's something that the Fourth Circuit recently illuminated in the El Masri case, and it's something that the D.C. Circuit discussed in the Halkin decisions. And that stems from the fundamental duty of the executive to protect the national security in our Constitution.
Why shouldn't we view the FISA law as having supplanted the common law doctrine?
Well, Your Honor, the plaintiffs in this case refer the Court in particular to one provision, Section 1806F. And that argument doesn't work for a couple of reasons. First, 1806 by its terms doesn't apply, and I'll explain why in a moment. And second, under this Court's decision in CASA, the Court determined that you need to conclude more than just that Congress legislated an area, but that there is a clear statement, a clear indication on the part of Congress that it intended to supplant the state secrets doctrine. And certainly no clear statement is in the law in this case.
Wasn't FISA enacted after congressional hearings and findings about abuses of telecommunications and interceptions of telecommunications?
It was, Your Honor, but one thing that both the text of the law and the legislative history makes clear is that the provision I think you have in mind, 1806F, is addressed to the situation where the government uses FISA-obtained surveillance against a person who knows he's been subject to surveillance. The one court that we think has come closest to considering this issue, and that's the D.C. Circuit and the ACLU Foundation versus Barr case, concluded that FISA does not impose an obligation on the government to disclose intelligence that's never been disclosed. And that's the question that the Court has before it.
So in your view, then, the state secrets doctrine would trump any congressional legislation in the FISA provisions?
Well, in our view, Judge McEwen, there is no provision in FISA that supplants the doctrine, and there is, in particular, certainly no clear statement on the part of Congress that intended to supplant it. And keep in mind, plaintiff's argument would require the Court to adopt the position that FISA establishes a FOIA provision, in effect, that would permit any criminal, any drug dealer, or any terrorist to come into court to bring suit to demand the United States to establish whether or not that person has been subject to surveillance and what type of surveillance.
Doesn't FISA have a provision for in-camera examination of documents and determination of secrets by Article III judges?
It does, Judge Hawkins, and it's in 1806F. That's the provision of the statute that deals with use of information, and if you look at the terms of that provision, it refers to situations where the government is either affirmatively using the evidence against an aggrieved person. That's the term that the statute uses, and it's a term that it defines to mean someone who knows he's been subject to surveillance. The plaintiffs in this case have not offered any bit of evidence or proof to establish that they themselves have been subject to surveillance, and therefore.
Let me ask you though. One of their complaints is that there is a widespread program for domestic surveillance. And if that's true, which some people have termed a dragnet, then wouldn't these plaintiffs, like everyone, be subject to that surveillance?
Let me respond to that in a couple ways. First, in fact, what they've alleged is that all or a substantial number, that's the language that comes from their complaint, have been subject to some kind of surveillance. So it's certainly not all. And second, more fundamentally, we don't think that a plaintiff can plead around the restrictions that have existed for decades on establishing their standing, on establishing an ability to proceed with a claim by pleading the broadest imaginable claim, a quote-unquote surveillance dragnet of all Americans' communications, which is something that the government, of course, has denied.
Well, may I ask you about that? Because I did look. I mean, President Bush said the government does not listen to domestic phone calls without court approval. Does the government stand by that position?
Yes, we do, Your Honor.
And so my question is, if that's true, and presumably there's evidence to back that up, since there would be nothing, since it doesn't happen, and there would be documents to back up that the President has or has not authorized that, why wouldn't at least that portion of the lawsuit be permitted to proceed to, in effect, come to verification of this statement by President Bush?
For these reasons, Your Honor. First of all, the court dealt with a similar issue in the Kaza case, where the plaintiffs sought to litigate the government's denial that the name of the location at issue was Area 51. And the court rejected the argument that because the government had made a denial, that the courts could litigate the veracity of that denial because the surrounding matter was shrouded with state secrets. Second, more generally, in effect,
let's stop there, because there it implicated state secrets. If the government is not, as alleged in the complaint, intercepting millions of customers' communications, why is that a state secret? Why wouldn't the government, in fact, want to put that on the record in a sworn statement in addition to President Bush's statement? Your
Honor, we would be thrilled if this litigation would go away if the government made that denial. But I would venture to guess that the plaintiffs wouldn't accept that denial, and that what they would want to do is force the government to prove the negative.
Good afternoon, Your Honors. This Court is being asked to change the plain meaning of words chosen by the legislature in a statute. The legislature drafted the unsafe driving statute using specific words and terms and to provide penalties for the offense of unsafe driving. The Appellate Division looked and analyzed the plain words of the statute and found that Motor Vehicle Commission's assessment of 4 points was proper. Petitioner is not asking this Court to change the language of the statute. She's asking this Court to change the meaning of the words in the statute. The Appellate Division rejected this argument. The facts are not in dispute. Petitioner was charged 4 times with unsafe driving in a 5.5-year period. Her third conviction occurred in 2006, where she was assessed points, which she did not appeal. Her fourth conviction occurred in 2007, 1.5 years later, where she was again assessed points. Petitioner contends, as you've heard, that because her 2007 fourth conviction occurred more than 5 years away from her first 2002 conviction, that she should benefit from the relief in subsection E of the statute. This contention is incorrect based on the plain language of the statute. Petitioner is not entitled to this relief because her third conviction in 2006 was only a 1.5 years away from her fourth conviction in 2007. Under the unsafe driving statute, a driver gets 2 offenses where they do not get points assessed. Upon a third offense, the driver will get 4 points assessed. Thereafter,
Thank you, Your Honors. The Attorney General petitioned to participate as amicus in this case due to the Crawford issue. So I will discuss the Crawford issue. The Attorney General's position in this case...
What issue here, based on
the
what is
part-
before us? The petition, which we granted, raised issues concerning the chain of evidence and the destruction of evidence. So why are we talking about Crawford?
Well, Your Honor, the appellate division held that the admission of the certified lab report in this DWI case violated Crawford.
I know there was no cross petition, so that issue is not before us. So
We submit, Your Honor, given that this is Crawford Day and a lot of Crawford issues are before the court.
Maybe you're seeing a bit of cognitive dissonance from the respect of Crawford Day.
And I know that this court has had its share of Crawford today, but we're asking this court if you will indulge me, because this is a very important issue, Your Honor.
But we have to first consider procedure. The parties in interest have not raised Crawford. You're amicus. You should be helping someone here in some sort of argument that hasn't been raised.
Your Honor, we petitioned to appear as amicus for the Crawford issue alone. In our certification, in our affidavits, we requested to participate because of the Crawford implications of the appellate division's decision, and this court granted our petition.
Are you going to argue that the appellate division made a mistake, a Crawford mistake, that hasn't been raised now by any of the parties? And
Your Honor, we're not here to argue that a certified lab report is not testimonial. And we're not here to argue that DWI defendants don't have a right to confront and cross-examine those who prepare certified lab reports. We're here, Your Honor, because the Attorney General is very concerned about the practical ramifications of a decision that Crawford applies. And that was the appellate division's decision in this case. That's why the appellate division's decision was published.
why didn't you petition?
There are particular...
The problem is, as Justice Alvin's been trying to point out, is that if that is such an important issue, then there should have been a cross petition. And this is an odd case, because you have the party who won at the appellate division filing a petition. So let's get past that. The party who purportedly lost in the appellate division files no petition. I'm sorry, I'm pointing at the wrong person. Okay? And the Attorney General, on an amicus basis, wants to raise what the party in interest chose not to raise. I mean, we work on certified issues. That's how this court works. And that issue is not certified to us.
Is the argument that you want to present on behalf of the Attorney General, is it presentable in one of the other cases? Because we have some similar type issues. Have you talked with other...
Your Honor,
Insofar
the
as
position that the Attorney General is taking in this case is different from the position that we take in Sweet, different from the position we take in Dorman. Our position is, with respect to those cases, that the admission of the document was fine because it wasn't testimonial. Here, we're not challenging that.
All right, but you recognize that from a procedural standpoint, we made a mistake in granting your petition.
Your Honor, I think we respectfully ask if Your Honors had not granted our petition, this may have come before the court in a different manner. Perhaps the State would have cross-petitioned to get this issue before the court.
It would have been briefed, and we would have had it in a little different perspective.
Yes, Your
This issue has not been briefed except by the one side.
Correct.
So
And
don't you
again,
think we should
because
wait until we get it briefed by both sides so that we can fully understand the issue and address it appropriately?
Well, I think, Your Honors, we raised it in our brief. I know that the defense submitted an opposition brief. We submit that it has been presented to this court. Both sides, the Attorney General and the defendant, have filed briefs discussing this issue.
You are tenacious.
Mr. Bornstein, we'd be glad to indulge you for 5 minutes on your recommendations that you put forward in your brief. We may not be able to get to them, but please proceed.
Okay.
Mr. Goldberg?
May it please the Court. I would like to reserve 5 minutes of my time for rebuttal. Emiliano Santiago asks this Court to declare illegal the involuntary extension of his enlistment contract with the Army National Guard beyond its specific termination date of June 27, 2004. He also asks that until the Court issues its decision in this case, his deployment to Afghanistan, which is now scheduled 2 days from now for Friday, be enjoined. In 1996, when Emiliano Santiago was 18 years of age and completing his junior year in high school, he enlisted in the Oregon National Guard for a specific term of 8 years. He did everything required of him during those 8 years, was promoted to sergeant, received fine evaluations. There is no question that under the terms of his contract, which is in turn consistent with the statute authorizing it, 10 U.S.C. 12302, Santiago could have been called to active duty at any time during those 8 years. But there is nothing in the operative section of his contract which applies to national emergencies declared by the President, which allows his contract to be extended whether or not he is called to active duty.
Mr. Goldberg, assuming that the common law of contracts applies to military enlistment contracts, and assuming that we have the authority to address the issue, why is it not sufficient under your theory of the case that Santiago's enlistment contract states clearly at various points that it is only a partial statement of applicable law and that it is always subject to change without notice by act of Congress or declaration of the President?
When one reads the contract, in fact, there is only one provision in the contract, and it's at the record at ER2, and it's section 9B, which does say that laws and regulations that govern military personnel may change. So we acknowledge that if a law was subsequently passed, it could have changed the provisions of the contract. However, Judge, that is not our case. In this case, the statute which the government was relying on, 12305, had been in existence for almost 15 years before Santiago signed his contract. And there is no mention of that provision in the contract, even though the contract cites every other statutory provision in the text of the contract, which applies or which allows the military to extend military enlistment.
Counsel, what about paragraph 11 that says the enlistee may at any time be ordered to active duty involuntarily under any conditions authorized by law in effect at the time of his enlistment or which may hereafter be enacted into law? What do you make of that language?
I'm sorry, is the court referring to paragraph 11 on ER 10 or paragraph 11?
ER 15.
On ER 15.
Yes.
That's an addendum to the contract. It's a statement of understanding of reserve obligations and responsibilities. And again, it talks about conditions which were in existence at the time of his enlistment. The condition at the time of his enlistment was not, there was no national emergency declared by the President during that time. We have no dispute, again, that he could have been ordered to active duty at any time during his contract. We do not dispute that fact. The issue, though, in this case is that if Santiago, for example, had been ordered to active duty a year before June 27, 2004, in June of 2003, that once June 27, 2004 came along, that date, he would have to have been discharged because there was nothing in the contract which specifically addressed the extension of his enlistment contract in this situation, in this case.
Mr. Colonel.
Thank you, Your Honor. First, I do want to address one open issue in terms of whether a fundamental right has been recognized in response to Judge Smith's question. The answer is not by any appellate court in the country, including Massachusetts, which relied instead on an idiosyncratic interpretation of rational basis. But I would like, before I address the specific issues, I would like to give a little historical legal development to explain why, when we reach the conclusion that what they're asking for is quite dramatic. Historically, the end of the 1800s, in the case Maynard v. Hill, is one of the first cases of the Supreme Court dealing with the concept of marriage. And essentially, there were two wives, and the man left the first one, went to Oregon, and married the second. And in Oregon, he obtained a divorce from the first one without telling the first one about the divorce. And he also inherited property. And the issue was, for the Supreme Court, who gets the property? And essentially what the Supreme Court said was the definition of marriage, who can marry, and how can marriage be dissolved, was exclusively for the legislature. And since the Oregon legislature had established the process for divorce, and the man had complied with that process, the second wife would obtain the property. New York was similarly situated. There's this argument that we haven't yet defined marriage, that we can treat it as men, woman, men, women, men. I understand the argument, but I don't stand ignoring Fearon v. Traynor. Because in the 1930s, in a case involving the abolition of the cause of action of the right to marry, this court specifically said that the marriage is between a man and a woman. But more than that, said that it's a contract between two people controlled by the state through the legislature. And if the legislature wants to abolish a cause of action, it had the right to do so. It has the right to...
The legislature's power over marriage is limited by, obviously, by the Equal Protection Clause under Loving against Virginia.
That's correct. I'm going to deal with Loving, but I'm only in the 1920s, Your Honor. But I will deal with Loving, and I'm going to tie. But at least as of now, there's exclusive control of the definition within the legislature. Mauricio was another case. It was decided by this very court, and indeed was the precursor to Skinner v. Oklahoma. In Mauricio, the woman refused to have sex with the man because he wouldn't go through a religious ceremony. And the issue was whether she could sue for abandonment and lack of support. And this court said that the reason for marriage is the begetting of offspring. It was the procreative aspect of marriage that it focused on, not the relationship of the two people, and said it was the foundation of civilization. And since the woman would not participate in the act which would lead to the procreation, she would not be entitled to support. Later on in the 1940s, the Supreme Court in Skinner v. Oklahoma actually mirrored that. And in Skinner, again, the emphasis was not on the relationship. It was on the procreation aspect, because the statute there allowed for sterilization where an individual was convicted of more than one crime of moral turpitude. If he was, he could be sterilized. And the Supreme Court said that marriage was so fundamental because of the procreative aspect, not the relationship.
What relevance is procreation today? The other side seems to say it's not too relevant, or at least that's, the relevance, I may be putting words in their mouths, but it's saying that it is not so central to marriage today.
But it is, Your Honor, because the purpose of the regulation of marriage is to encourage stability by having the solemnization where you have two people who procreate and have issue. What you want is encourage stability of the family. Does that mean...
Have medical advances changed that situation?
Yes. And all that means is an argument can be made before the legislature that there is a reason to include another group that is not exactly similar. But the vast issues still come as a result of biological procreation between man and woman through the marriage. I'm sorry.
How does allowing same-sex marriage intrude upon that state interest?
But that's not the issue. The question.
But how does it?
Excuse me?
How does allowing same-sex marriage intrude on
it doesn't.
Or impair that
but
state
But
interest?
under the rational base, which I'll get to, that doesn't matter. It's not. The question is whether or not there's a rational basis. If, as we contend, the purpose is still viable, then the issue is whether there's a constitutional compulsion to include them, not whether it's desirable, because after all, when you decide there's a constitutional compulsion on the least substantive test, rational basis, you are saying the legislature cannot choose to include. You are making
and procreation is the only rational basis for the heterosexual marriage, or is it?
It is the emphasis, yes. Yes.
Is there any other rational basis?
It ties in with tradition and the management of tradition, but the main reason...
Is the upbringing of children something different from procreation? Could the legislature prefer that children be brought up in opposite-sex households?
Do I think they can make that judgment based on a study? The answer is yes, but I don't believe that's the original reason. The original reason was to create a process where when men and women get together, society has judged that this would increase stability. They were dealing with the vast... Look, there's no question you could argue, for example, that people who can have children shouldn't get the benefit of it. But if a statute is over or under inclusive, you don't throw out the statute, you compel including another group. You say to the legislature, hear their arguments, and if they have legitimate arguments, as the Supreme Court has said, in the end, that those arguments will be sustained and they will be included.
How do you deal with
I was
Turner
going to get
against...
to Loving. I didn't forget.
No, well, I'm going to distract you again.
Okay.
Now I'm going to ask you about Turner.
That's my next step.
How do you deal with Turner against whoever it was, where the Supreme Court held that two prison inmates who were in different prisons and not going to procreate with anybody, that they had a fundamental right to marry?
But what they said in that particular case, at some point, those inmates would be hoped to be released, and you still had the purpose of the marriage and the procreative aspect. Again, marriage doesn't mean that everybody within it fits the definition, but if it has a purpose that's rational, the fact that it's under or over-inclusive doesn't mean you automatically...
In response to Justice Albin's question, isn't there a thread here? Isn't there some scheme that we can follow? I say there is. And I represent to you, Justice Albin, that scheme, that piece of thread, has been my overreaction to what I perceived to be an injustice that occurred, or a lack of justice. That is the thread that continues and has continued since my days as assistant U.S. attorney, prosecutor, county executive. I can't abide that. Maybe better now in the civil division, but I had trouble abiding that. In 150 criminal trials, one case I went into a jury that had witnessed indirectly the failure of a threat to a witness, a beating of another witness, and a reaction to a situation that troubled me so much that I went to the jury and I said rhetorically, what were you thinking? The ACJC did not comment on the 3 letters I received from the jurors in that same trial, which were largely mitigating, and the reactions to the people as jurors.
Judge, you realize you're a judge and not a jury.
I do understand.
You know the term, you're not the judge and the jury.
Nor did I try to be. Nor did I try to be, Justice Albin. I never went in there to convince anybody or reprimand them. I go in there to explain and respond to questions they have.
Let me read to you one of the things you told that jury, and to which you have admitted. You told them that the defendant would have testified if he had been not guilty.
No. I told him that he would have testified.
I'm reading to you from the complaint that you admitted. You admitted that you said that according to the complaint. And now, are you denying that?
Yes. What I did say was that the defendant would have testified had he not had criminal convictions. That was the reason I said. I didn't say that he was not guilty.
There may be civil juries that you disagree with, that you may feel just went down the wrong road.
I've had that, and I have been able to control myself with much greater alacrity than might have been the circumstance with criminal cases, and particularly as I would refer to the comment with Justice Judge Grohl.
And we don't get to substitute our judgments for the jury. That's the way the system works, and we're supposed to show respect
I sincerely appreciate that, and in all cases but that case. My real point that I wanted to indulge in was the general consensus or the general feeling that the genesis of my being here before you today is a product of State versus Harris, and that the other charges are, all things considered, relatively insignificant when you think of State versus Harris.
Your remarks to Harris weren't from the bench. They weren't slips of the tongue. You prepared a long written opinion. One of the issues that you were asked to decide was the constitutionality of the death penalty. And apparently within the first paragraph on that particular issue, you determined that there was no violation. And then you go on to speak about your personal opinion about the death penalty system in this state.
Yes, I did.
It had no relevance at all to the case. It was you on a soapbox with your robes on, speaking how you felt. Was it anything more than that?
I would like to think it was. I would like to think that it was.
How was it? It wasn't related to any issue that was in dispute. It was a political pronouncement by you in robes. And I don't know how you can even begin to justify that now.
Well, political announcements and pronouncements have been made by people in robes in this state, in this Supreme Court, in the lower courts of our state.
You don't get the opportunity when you're in robes to get on a soapbox and make political statements. You're there to decide a case. The issue was the constitutionality of the death penalty. You had nothing to say on that subject and then went off on this tirade. You were asking the legislature to basically repeal the death penalty. What gives you that right as a judge on a bench in robes?
What gives me the right, I guess...
You weren't arguing on constitutional grounds. You were arguing on public policy. Like we should just take this up.
My invitation was to declare the death penalty process unconstitutional.
You never said that. I'm quoting you. One might hope instead that this state and its citizens would, if no more than as a consummately practical deduction, simply resolve to set aside the comfortable pieties of the argument, eliminate the death penalty of the game. ... It's not your business to ask for a law that you may disagree with to be repealed. It's just not within your province as a judge.
Then with
and that's part of understanding what your function is as a jurist.
You understand that?
Justice Azali, I'm not I know the easy answer would be yes, but I'm not sure that I do.
You want us to sanction other judges being able to speak on any irrelevant subject merely because they happen to be on the bench?
In the course of their opinions?
Yes, in the course of their opinions.